Having lawfully asserted my standing, I issued notices of obligation and fiduciary duty to relevant public officials, including the ATO Commissioner and Registrar General. These documents stated that as trustee beneficiaries to the trust estate created in my all-caps name, they are bound by fiduciary principles under equity, and any further action against me without consent would be ultra vires, beyond their legal authority. I filed an affidavit of truth, unrebutted, establishing my facts as law in commerce. Subsequently, I filed a common law commercial lien on my legal name, recorded via third-party witnesses and published online. This served as notice that any unlawful use of my legal person would incur damages backed by sworn testimony. To formalize control, I executed a private irrevocable power of attorney from the legal fiction, John Smith, to the living man, John of the family Smith, notarized and recorded with an international notary service. This move was designed to establish agency between the fiction and myself, giving me lawful authority over all actions taken in its name. Using my private trust structure, I opened a non-public trust account through a credit union styled under my trust title. Though this account was still under standard regulation, I treated it as a holding mechanism for trust transactions and managed all correspondence under my trust's letterhead, asserting private status under contract law principles. I created a document titled Sovereign Estate Ledger, listing all presumed assets, liabilities and instruments issued in the name of my legal person since birth. This included birth certificate registration number, tax file number, Medicare ID, any bank accounts, bonds and policy numbers tied to the name. This was served on the Commonwealth Treasury and Reserve Bank with a demand for equitable disclosure under trust law. Following contract law, I responded to all government demands, fines, tax assessments, legal summons, with conditional acceptances upon proof of claim. Each response included a statement reserving all rights under UCC 1-308, proof of my previously submitted rebuttals and trust documentation, and a demand for wet ink signatures, valid contract evidence, and fiduciary bond insurance. I uploaded all documentation to blockchain-based affidavit repositories and submitted them to international claim repositories for public record. This ensured immutable timestamping and proof of notice to the world, consistent with the principle of constructive notice in law. When public bodies failed to rebut or respond in lawfully required time frames, I entered their silence as tacit agreement. Through a three-step process, notice, opportunity to cure and default, I lawfully established default judgments in commerce and equity. I refined my trust by adding a second trustee, a trusted associate creating a letter of wishes, and preparing a private trustee indemnity bond in case of legal challenge. This allowed the trust to function more autonomously, and I began transferring personal property and intellectual assets into the trust corpus. Today I operate not as a public subject but as executor and settler of my estate in trust. I interact with public entities through conditional contracts only. My legal identity is no longer presumed abandoned, it is under claim, and I continue to assert that all fiduciaries must now act in my interest or face personal liability under the maxims of equity. This journey is not advice, but a testimony of one man's assertion of status, estate, and capacity in a world of presumed contracts.